conservatorship is a court-ordered legal relationship that gives a person certain rights, powers, and duties regarding another person's financial and health matters. The likelihood of your financial and health matters becoming the subject of a conservatorship increases if you do not have an estate plan. How does the conservatorship process work? A conservatorship proceeding is initiated when a person files a petition for conservatorship with the probate court. The court may grant a petition if the person proposed to be conserved, called the conservatee, is unable to make sound decisions or care for themselves or protect themselves from fraud or undue influence, and the conservatee has not made any arrangements for that situation in advance by establishing a power of attorney or living trust. The court must determine that a conservatorship is the least restrictive alternative available to protect the person. If the court determines that a conservatorship is the least restrictive alternative available, the court will appoint a responsible person called a conservator to assist the conservatee who's unable to provide for their personal and/or financial needs. There are generally two kinds of conservatorships. First, a conservatorship of the person, where the court appoints a conservator to care for and protect the conservatee and provide for the conservatee's needs associated with daily life. Second, a conservatorship of the estate, where the court appoints a conservator to handle the conservatee's financial matters, like paying bills and collecting the conservatee's income if the conservatee has an estate. The conservator must report back to the court on their activity on a regular basis, which provides the conservatee with some safeguards to ensure the conservator is acting appropriately. Even if a person appoints an attorney in fact who could manage their assets and make future healthcare decisions for them, that person should still document their choice of conservator in case a conservatorship is ever necessary. The conservator might be someone who the person previously nominated, or if no one had been nominated, it might be the person's spouse, registered domestic partner, or another family member. If none of those persons are available, then it might be the public guardian. Any responsible adult can act as conservator, and there can be more than one conservator. Conservatorship proceedings are designed to help protect a person at a time when they are vulnerable or incapable of managing their assets. However, conservatorships are public in nature and can be cumbersome, expensive, and time-consuming because of the substantial court intervention. Conservatorship proceedings may be less flexible in managing real estate or other interests that a living trust or appointment of an attorney in fact under a power of attorney. One special type of conservatorship is called the limited conservatorship. In a limited conservatorship proceeding, a judge may appoint a responsible person, i.e. the conservator, to assist an adult with developmental disabilities, i.e. the conservatee, who is unable to provide for their personal and/or financial needs. An adult with developmental disabilities is someone who has severe and chronic disabilities because of a mental or physical impairment. Generally, a person is developmentally disabled if they have an IQ less than 70 or they are diagnosed with autism. Other conditions can qualify too. A limited conservator's duty is to help the limited conservatee develop maximum self-reliance and independence. At the court hearing, the judge will say exactly what rights the limited conservator has. Because developmentally disabled people can usually do many things on their own, the judge will only give the limited conservator power to do things the conservatee cannot do without help. The limited conservator may decide where the developmentally disabled adult will live, but not in a locked facility, look at the developmentally disabled's adult confidential records and papers, sign a contract for the developmentally disabled adult, give or withhold consent for most medical treatment, but not sterilization and certain other procedures, make decisions about the developmentally disabled adult's education and vocational training, place the developmentally disabled adult at a state hospital for the developmentally disabled, give or withhold consent to the developmentally disabled adult's marriage, control the developmentally disabled adult's social and sexual contacts and relationships, and manage the developmentally disabled adult's financial affairs. The court will supervise the limited conservator, who will have to report at least annually to the court. A court investigator will review the case 1 year after the conservatorship is granted, then every 2 years after that. The investigator will also visit the conservatee. The court will appoint a lawyer to represent the interests of the proposed limited conservatee and to review the petition for limited conservatorship. These services are free unless the proposed conservatee can't afford them. An attorney licensed by the State Bar of California can advise you about the conservatorship process. If you are not represented by an attorney, the Self-Help Center of the Probate Court may provide assistance, including with filling out any forms required to be filed.